Thank you very much, ladies and gentlemen. It's a pleasure to be with you and maybe to discuss about the same issues that you have discussed during the last 2 days, because it's very important to think about the role of differentiated integration in the story of the European Union. As the number of member states increased, and the competence of the Union widened, some member states have at times opted out from participating in new fields of integration. I will argue that having a degree of flexibility has maybe allow the Union to grow in size without us growing apart. And differentiation has proved in certain cases to support the resilience and functioning of the European Union. It therefore remains maybe a necessity in a number of EU policy areas. Take the case of the Economic and Monetary Union, for example. I have the opportunity at the national level to be a member of the ECOFIN and the Eurogroup during 12 years. So I've seen the evolution in such a field, but it will never have been possible to have a single currency without giving member states the choice as to when they join. So it was very clear that we need to start with around 10, 11 members, and then to extend to Greece, but not only to Greece, and slowly to other member states. And now there are more members of the Eurozone than members of the European Union. At the beginning of my mandate as Minister of Finance, we were 15 in the European Union at the time, and now we are more in the Eurozone. So it was very useful to work with such a kind of process. And the Euro Plus Pact adopted in 2011 was entirely voluntary. 5 member states chose not to participate, but it helped those who was most needed to make changes that were beneficial for European economic policy, including Greece, Ireland, Malta, and Spain. Differentiation continues to exist effectively in the banking union if you continue to work in the economic and financial sphere. When Herman Van Rompuy was president of the European Council and I was deputy prime minister of Belgium, I argued strongly in favor of common monitoring mechanism, common deposit guarantees, and common rules for solving bank crises. We have tried to organize some lessons from the financial crisis, and during the Belgian presidency in the second part of 2010, we have put into place different new instruments in such a way. But the fact that these elements had been missing was one of the most important lessons we learned from the creation of the euro in 1999. Today, these elements are there, but the banking union still does not involve every member state. Moreover, it functions explicitly to take into consideration the interest of non-participating member states. Other well-known examples of differentiation include the Schengen area and a number of instruments in the area of border checks, asylum and immigration, and police and judicial cooperation in civil and criminal matters. Some may argue that the result is the EU only being able to achieve a certain level of integration and nothing more. But I would argue that it was the only way, and I'm in charge of this since 2 years. I must say that it's very important to continue to work with the same kind of method if we want to be efficient. As for economic and monetary policy, differentiation in home affairs in both the depth and scope of integration has always been a pragmatic necessity for European integration, and it continues to be. In the field of justice, so in my portfolio, which I oversee as European Commissioner, the creation of a European Public Prosecutor Office, the PPO, is an exceptional example of differentiation. The Prosecutor Office is the first union body that is competent to exercise direct criminal law powers vis-à-vis individuals. As such, the European Public Prosecutor Office represents a Copernican revolution in the history of union law. The PPO is competent to investigate and prosecute crimes affecting the union budget, notably fraud. So far, by coincidence, Hungary and Poland have decided not to join the PPO. Sweden is out, but announced it will join in 2022. The decision will be taken maybe during the autumn. And Ireland has not yet exercised its right to opt in. Finally, Denmark enjoys an opt-out from the measures concerning the area of freedom, security, and justice. But it was the only one possibility to start on the 1st of June last year with the operation of the PPO with 22 participating member states and not all the member states. Nevertheless, the broader context in which the PPO operates is underpinned by remarkable integration. Since all member states benefit from the union budget, the treaties require each of them to protect the union's financial interests irrespective of their participation in the prosecutor office. Furthermore, the non-participating member states have an obligation to cooperate with the PPO on the basis of the existing EU instruments of judicial cooperation and in accordance with the principle of sincere cooperation. And in addition, the PPO can conclude working arrangements with the non-participating member states to better regulate their mutual cooperation. The PPO already concluded a working arrangement with the General Prosecutor of Hungary. In addition, discussions are ongoing with the other non-participating member states, and the Commission pushed pressure to conclude such a kind of arrangement, and of course will take initiative if it's needed to have such a result, to have real arrangement with all the non-participating member states. With its activities, the PPO contributes to upholding the rule of law in the Union. And this brings me to the topic of the rule of law, because as member of the Council during, if I well remember, 40 different presidencies, since 1999 till 2019, I've had the opportunity to work with differentiation, I said, in the way to organize the monetary and economic policy, and certainly with the Eurozone and the Eurogroup. I've seen the evolution to the banking union, but I've had also the opportunity to take part in the Geneva Council and to try to see how it's possible to have the same approach for the rule of law than for the budgetary situation in the member states. You know that since many years, we are discussing euro by euro the budgetary situation in all the member states, the structural reforms, pension schemes and others, but not the values. It was very difficult to engage a real dialogue on this, and so since 2016 I've proposed to organize a peer review about the rule of law in the Geneva Council, and it was a long process. But of course, I want first to say that there are certain areas of EU action that lie at the heart of the European Union and underpin its very existence. In these areas, differentiation and flexibility cannot be envisaged. And all member states need to demonstrate their full commitment and adherence to a set of common values and principles. And above all, this concerns the adherence by the member state to the core values set out in the Article 2 of the treaty: respect for human dignity, freedom, democracy, equality, the rule of law, and respect for human rights. These values are common to the member states in a society in which pluralism, non-discrimination, tolerance, justice, solidarity, and equality between men and women prevail. I would like to tell you more on the importance of these values and what we are doing within the EU to uphold them. I said since 6-7 years we have started in all the European institutions to discuss about that. It's a new process, but now we have a lot of tools at our disposal. At the end, I will also say a few words about the external dimension of union action, which these days has become incredibly relevant and important. Indeed, the universality and importance of these values has become even more prominent in relation to the events unfolding in Ukraine as we speak. I will say that, to my mind, I've said that also to the Parliament, it's more important, a fortiori now, to work on the rule of law in the EU and to ask a full application of our rules at the moment where we are asking to Russia to have a full respect for international rules. And of course, we know that it's not the case, so we have engaged a process with sanctions. But if we want to be credible in the way to organize a rule-based international order, we need to be ready to continue to work also on the full implementation of our own internal rule of law system, because we are sharing, I said, the same value. A number of challenges to the rule of law across member states have brought to the forefront the need to uphold the rule of law within the EU. Member states have different legal systems, it's true, and traditions. It's also maybe a differentiation, but the core meaning of the rule of law is the same across the European Union. The core principles that define the rule of law are set out in the case law of the Court of Justice and of the European Court of Human Rights. And you see that now we have the same kind of evolution in the two courts, as well as in the work of the Council of Europe in general. These key principles are common to all member states and are enshrined in national constitutions and translated in legislation. They include legality, legal certainty, prohibition of arbitrariness of the executive powers, effective judicial protection by independent and impartial courts, effective judicial review, including respect for fundamental rights and equality before the law. These principles are the vehicle for ensuring compliance with and respect for democracy and human rights. Respect for the rule of law is intrinsically linked to respect for democracy and for fundamental rights. There can be no democracy and respect for fundamental rights without respect for the rule of law and vice versa. Democracy is only protected if the judiciary is able to fulfill its fundamental role and guarantee freedom of expression, freedom of assembly, and respect of the rules governing the political and electoral process. Fundamental rights are effective only when they are justiciable. If it's possible to go to justice, and it's a guarantee in the Charter of Fundamental Rights to have an access to an independent judge, and if it's possible, a qualified one. Respect for the rule of law is also the foundation of mutual trust among member states. It is therefore vital for the functioning of the whole EU. And this is why the Commission has developed and used a variety of instruments to prevent and address rule of law challenges within the European Union and without any differentiation. We try to work on an equal footing with all the member states. And the annual rule of law report was added to this toolbox in 2020. It was maybe the consequence of our first discussion that I've mentioned in the Geneva Council some years ago about a possible peer review. It is conceived as a yearly process. It helps us understand potential problems that can be addressed by member states before they get too deeply entrenched. It also allows member states to learn from each other through an exchange of best practices, notably in the Geneva Council, where a peer review discussion is taking place about 5 member states every semester. And we are going to the end of such a tour with the next presidency, the Czech and the Swedish presidency, and we'll restart a new tour of the 27. The 2021 Rule of Law report has further developed our country-specific knowledge, and based on the experience gained in the last 2 years, the 2022 Rule of Law report will, for the first time, include concrete recommendations to member states, so it will be easier to organize the follow-up. At the same time, we will continue making use of the other tools to uphold the rule of law, such as infringement proceedings and the preventive and sanctioning mechanism provided for in Article 7 of the treaty. And you know that we have two procedures on the table of the Council about Hungary and Poland again on the basis of Article 7. The rule of law conditionality regulation links the distribution of common EU funds with respect for the rule of law. This month, the President of the Commission has announced that we will launch the conditionality mechanism as regards Hungary. This further underlines our common belief that the rule of law underpins the very functioning of the Union. We have started with an administrative letter in November last year, and it was more in line with the fight against corruption. It was one of the country-specific recommendations in the European semester, and we ask, of course, to receive a correct explanation about possible reforms to strengthen the fight against corruption. Without that, we have decided to start the process with a notification. But respect for the rule of law cannot stop at the Union's border. And I said I will conclude maybe with remarks also at the external level. Pressure on the rule of law can be observed globally. I don't want to repeat what I've said about the violation by Russia of different international laws, of course. And the EU is working actively to protect, inspire, and support democracies around the world. We have all been profoundly shaken by the atrocity of the unprovoked Russian aggression against Ukraine. No more than ever, the EU, as a beacon of peace, needs to uphold and promote its values with determination. And so I said, a fortiori, we need to continue to work on the rule of law if we want to be credible in the external world. There has been a clear consensus amongst member states on the need to ensure the enforcement of Union sanctions against Russian individuals and companies. The newly established Freeze and Seize Task Force, set up by Commission, has been supporting member states to do this. It also aims to explore the links between assets belonging to persons listed under the Union sanctions regime and possible criminal activities. If there are criminal activities linked to those persons, it's possible not just to go to a freezing of assets, but to a confiscation. And if you are doing that, we ask to the member states to put the money in a trust fund for Ukraine, so to give, in fact, the money back to the victims. So it's the first task. With the task force, I'm steering the task force with all the member states and with the different agencies, Europol and Eurojust, and the perpetrators of war crimes that are likely being committed in Ukraine must be brought to justice. Our agencies, again, Eurojust and Europol, plays a key role in this context. Eurojust is currently supporting a joint investigation team that conducts investigations of the crimes committed in Ukraine. So we are doing the same outside Europe in such a situation in Ukraine. I'm fully committed to ensuring that Eurojust can deliver on its mission, and the Commission is planning to reinforce Eurojust's powers vis-à-vis war crimes accordingly. And we have for the moment a joint investigation team with Poland, Lithuania and Ukraine working together in Eurojust. I have asked to all the 27 to think about the possible participation if they start investigation in their own country, because that you know that the testimonies about the war crimes are collected not only in Ukraine on the ground, but also in many member states due to the presence of refugees in the member states. And we need to collect evidence to organize prosecutions and then maybe trials and to bring people responsible for those war crimes to justice. Finally, we are also working on the opinions on the applications for EU membership submitted by Ukraine, Moldova, and Georgia. So we continue to discuss about the so-called enlargement, and this brings me to the importance of the rule of law again in the context of enlargement. Article 94 of the Treaty on the European Union provides that any European state which respects the values referred to in Article 2 and is committed to promoting them may apply to become a member of the Union. The Copenhagen criteria further detail the conditions to become an EU member state. One of these conditions is the stability of institutions, guaranteeing democracy, the rule of law, human rights, and respect for and protection of minorities. There is a reason why we take a fundamentals first approach to enlargement, which means that progress on the rule of law determines overall progress in accession negotiation, because the rule of law is not non-negotiable, and there is no case for differentiation here. We need to have all the member states at the same level in the way to organize a good implementation of the rule of law. This principle, which has been strengthened by the enhanced enlargement methodology, will continue to guide our action. Conducting rigorous and objective assessments of the progress on the rule of law reform remains a priority for the Union. At the same time, I do believe that we can facilitate the participation of candidates and potential candidates for EU accession in EU programs and agencies. For instance, discussions are ongoing with some of our Western Balkans partners regarding their possible participation in the Justice and Citizens' Equality, Rights and Value to Serve program, among others. But EU accession can only be realized on the basis of credible and tangible results on the rule of law, including an independent judiciary, respect for fundamental rights, media freedom, and an effective framework to tackle corruption and organized crime. Differentiation certainly works in EU policy making, it's true, and in fact, it is arguably the only way the EU can move forward in certain areas. But it only works where there is an underlying and shared belief in what the European Union is. We are a union of values. These values are set out in Article 2, I said, of the Treaty of European Union, and they are non-negotiable. We cannot allow for practices that diverge from these values. The reality, which we have seen in Poland and in Hungary as regards the rule of law, for example, damage the integrity of the Union. And I want to pay tribute to the very complex discussions you have held over the last days, because I'm concluding with a very simple statement. But I'm sure that it's important to recall that it's very useful to work with a certain level of differentiation in different policies. But in my portfolio, it's impossible to do that when we go to the rule of law issue. And just to say that I know that there are many discussions about the different cultures, the different traditions, the different legislations that we have sometimes in different member states. We don't ask to have exactly the same judicial system or the same legislations in all the member states. We just ask to apply the same principles, to have a good reference to the same common approach about the values. And that's very important. And again, it's impossible to agree on a differentiation on this. And I have listened in the last weeks and months many comments about the fact that if we have a majority in the parliament, it must be possible to pass a law. Why do you want to go to the court against a law adopted by a majority? But all the laws are adopted by a majority. But you know that when we try to protect the minorities, it's just again against the majority. So the adoption by a majority in the parliament, or it was an attempt in the last elections in Hungary to organize a referendum and to have the support by a majority of the population, is not enough to say that there is no discrimination. So we want to protect also the minorities against, of course, the use of different kind of competences by the majorities in the different member states. And so again, we don't ask to have exactly the same system. We ask just to have a full respect for the values. And it's not an imposition by Brussels. I've listened many times. It's a condition put in the discussion by the Commission. No, it's a self-commitment by all the member states during the accession. When you organize the accession to the EU, you agree on the treaties and you agree on the Article 2 and the values. And so in some member states, it was by referendum again. So it was very clear that it was a clear commitment. But when it comes to our values, I said, sometimes simple is good. And also after the Brexit, I will maybe quote Churchill. Sometimes we have good inspiration from outside the European Union. All the great things are simple, and many can be expressed in a single word: freedom, justice, honor, duty, mercy, hope. And I'm sure that we need to continue to try to be very concrete on all those values that we try to apply without any differentiation within the EU. Thank you very much, and I will, of course, be able to answer to your questions.
Thank you, Commissioner. If you want, you can join me here. I know it's already 1:30, but maybe we can have time for a couple of questions from the audience. And then, yeah, please. One over there.
Thanks so much, Commissioner, for these very insightful words. I'm Camila Mortera, Center for European Reform. I work on rule of law, and I have a question about the new rule of law reports that you rightly said would, for the first time ever, includes recommendations to the member states. My question is simple. How are you going to act on these recommendations after they are made? Thanks.
First of all, yes, okay, fine. Now, first of all, it's not really new, the recommendation. The terminology will be new, but if you have read the two first reports, the conclusions were very clear. I was in different national parliaments to discuss the country chapters, and all the time it was very clear where we have put some conclusions in the chapter. And now we will go to concrete recommendation. To do what? First of all, to be more evident in the way to organize the follow-up. It will be very important to ask to the member state to follow, of course, the recommendations, or to explain why they want to do something else or in a different way. So it will be easier, I'm sure, for all the stakeholders to point out the recommendations and then to verify year after year if there is an evolution. Because I want to insist on the fact that the rule of law report is a part of a cycle now. So it's not just to put a report in the library, it's more to organize a follow-up all the time. So we have had the first report in 2020, but now we are going to the third one. Of course, in all the next reports, we'll explain what kind of reactions we have had from the member states, what kind of improvement of the situation, or what kind of lack of improvement, of lack of reforms. And the recommendations will help to define what is necessary to do to improve the situation. I want just to conclude to say that what we ask to the member states not to be perfect. Nobody is perfect, and certainly not the member states, but the Commission too. But we ask to make progress. And one of the most important elements that I will repeat maybe in the future about the rule of law report is the principle of no regression. You are not in full compliance with all the European standards. Okay, it's the case maybe in all the member states. But if you organize reforms, is to make progress. If you organize reform to go back, we have to react. And in the recommendation, we'll be also able to do that and to say that. And so all the time, the dialogue on the basis of the rule of law report and the recommendation will be to improve the situation in all the member states. And I will say, after 2 years now, we have a very good result with many proposal, action plan, that is not new, but also real reforms, new laws in many member states to improve the situation. Unfortunately, till now, we have 2 systemic issues in 2 member states. And again, it's not by coincidence that we have 2 procedures under Article 7, and that we have had so many discussions about the recovery and resilience plan and about the conditionality mechanism and order all the time with the same usual suspect.
If there's, okay, one there and one. I'll take just these 2 questions and then go back to the Commission.
Okay, my name is Ivan Damianovsky. I'm one of the researchers involved in the UIDEA project. My question is related to your remark on the features of rule of law policy within the EU, where you said that basically the fundamental point of that policy is that for the member states to respect in a way, the value of rule of law, but there are no demands upon them on how they organize the judiciaries or in general the institutional aspects of rule of law. But on the other hand, there is a contradiction when you compare it to the accession process that you also mentioned, where rule of law is the key feature of EU conditionality in regards to the countries of the Western Balkans. And it is a problem that we in the academic world call the disconnect problem, where on the contrary, conditionality policy in the field of rule of law in regards to the Western Balkans seems to be based on a completely different, opposite strategy, where judicial organization, which is the key aspect of conditionality policy, is centered on the idea of organized, even I would say integrated models of judicial organization, which are centered around the idea of strong judicial councils and training academies. So basically all the countries of the Western Balkan, including one member state, Croatia, basically have to follow this integrated model, which is different from the idea of you can do whatever you want with judicial organization as long as you just respect the core value of separation of power and independent judiciary. So I would like a comment on this disparity, obvious disparity that we have.
Commissioner, I'd be grateful if you could say something about the powers and capacity of the fundamental rights with Vienna, and the agency, which has been is subject to a degree of criticism, which I don't think has as yet been soundly addressed. Thank you.
Thank you.
Maybe just to react. First of all, I said we don't ask to the member state, but also not to the candidates, to put into place exactly the same judicial system, or to give you another example, the same electoral system. You know that we are now with very important elections, I mean in Slovenia, in the next days. Everybody was looking the last debate with the Slovenian candidates in the last hours, I'm sure. But we have all the time elections, but we have 27 different electoral systems. It's the reason why maybe yesterday is the only one occasion in the European Union to see two candidates for a presidential election with a real capacity to organize then the policy in the country, because it's a real presidential system. I know that we have some other presidents in Europe, but not exactly with the same presidential system. But if you look to the 27 electoral system, they are so different that it's very difficult to explain to the citizen of one country what is at stake in the other one. I'm sure that in France, they are looking to the presidential election. They don't know that all the voters in Germany have 2 votes, and that there is not a fixed number of members of the parliament. That depends from the results of the 2 votes. Fine, I don't want to go further in the explanation. I don't want to explain the situation in Belgium, it's too complex. But what we ask at the end, it's to be democratic and to have fair and free elections. In Hungary, there was an observation mission from the OSCE, and it was said it was quite open as election. Now we are waiting for the final report about the fair process. That is something else. But so it's possible to be democratic with totally different system. If we look to the judicial system, it's the same. It's quite possible to have different system. To give an example, we have start infringement proceedings against some decisions of constitutional court in different member states. But we have constitutional court in around 15 member states, no more than that. Sometimes the Supreme Court playing the role, sometimes no mechanism like in the Netherlands. So we don't ask the same. It's true that for the National Justice Council, there are different names in different member states, we have a reference. It's a reference of a decision of the Committee of Ministers in the Council of Europe. So the candidate countries are some members. So it's not new for them. They are members of the Council of Europe. And there, the decision is to have a majority of the members of the Council, that they are judges elected by their peers. We have asked constitutional revision in Luxembourg to do that. We have huge discussions in Spain to try to do the same. And I don't want to mention all the different member states when we try to do that. But except that, it's possible to have different organizations in the justice system, but we verify that you have an independent justice system and there is an access for an independent judge for all the citizens and the company. And also with the accession countries, we try to work in the same way. I know that sometimes it's easier to ask to copy the system of one of another member state, but we don't have a model. We have different systems and we are very open to make progress with the candidates like we try to do with the member states and without an harmonization or without the organization in the same way, but with a respect for the same values. And in the respect of the values, of course, FRA, the Fundamental Rights Agency, is criticized, but it's normal, because if you explain all the time that you have seen some discrimination, some violations of the fundamental rights in different parts of the European Union, just to speak about the Union, of course, you receive criticism from local authorities, regional authorities, national authorities against your approach. But what we try to do more and more is to have more and more surveys coming from FRA to explain the situation. In another kind of process to put into place some concrete solutions or instruments. To give an example, for the European arrest warrant process, or to the extraditions, to be more concrete, the judge need to verify if it's possible to send some people back to another member state with quite good conditions in the prisons. And now we have a data bank in the FRA with the situation in all the prisons in the European Union. And they have two effects. Of course, they give the opportunity to the judge to verify if there are enough conditions to send back one people. But we have seen the pressure on the member states to try to go to a better situation in many different prisons. And that's very important. So to try to use the analysis made by FRA in the prisons to put into place an instrument. And then my last comment is that I've asked FRA to come to me with a proposal about the follow-up of the rule of law report. Because the rule of law report, for the moment, I have the opportunity to discuss the report in the Council. Well, of course, in the Commission, because I propose to the Commission and we adopt. That's the position of the Commission. But after that, we have a discussion in Geneva Council in general. Then I said 5 member states in one session every 6 months. We have discussion in the Justice Council about the justice system, of course. I will try to discuss that in other formation of the Council. We do the same in the Parliament. I will say, I repeat that all the time, my problem with the Parliament is that they want just to discuss about 2 member states. And I said, no, we need to discuss on the 27. But I know that it's more important to discuss about Hungary and Poland and to let the others aside. But I repeat that I'm very open to do that. But what is more important is to go to the member states. I try to do that, to discuss with the national parliament. I mean, also to the opposition and not only with the majority, to the civil society. But if I'm doing that, it's 2-3 days maximum a year. So I ask now to have discussion with civil society, with think tank, with organizations, but also with professionals in the justice system. Why not with the bar associations, with the notaries, with judges and so on, and to have a follow-up during the whole year, not just to wait the publication of the next report and the recommendation I described this year, but to engage a real debate. Because the ultimate goal, and with FRA is the same, is to install a culture of the rule of law, of the respect for fundamental rights. And to install the culture, you need to go in the member states and you need to discuss not only with the authorities, but with the civil society, and more than that, with a very large number of citizens. And I try also to do that with the young people, but again, not only in the universities, it's pleasant to do that, but also with people, young people at work, with people in other kind of studies, because it's important to install a culture. And the difficulty, and FRA may help in such a way, is to explain that rule of law is not abstract. It's very concrete in the daily life of the citizens. When we speak about the discipline of the judge, like in Poland, it seems to be FRA. It's the problem of the judge for many people. But when you explain, if you have a problem and you need to go to a judge, it's better to have an independent one. You receive a refusal from the authority and you need to go to the judge to cancel the decision of the authority. If the judge is exactly on the same line with the authorities, you don't have any chance. And so we need to explain more what that means in the daily life of the citizens, like in the daily lives of the companies, because now we have more and more problems with company having an hesitation to invest in some member states due to the fact that after that, if you have a problem, you need to go to a judge, and with what kind of certainty about the independence of the judge. So FRA may use its own expertise to do that and to explain maybe better what is at stake, what is possible to see in the daily life of the citizen, and not to have an abstract discussion on the rule of law and the core values without tangible, concrete situation for the people.
Well, thank you very much, Commissioner. I think this was a perfect conclusion of our event, also because basically your assessment coincided with the results of our research project for 3 years and a half. We also concluded that, in fact, flexibility and differentiation can be a tool for policy effectiveness, but at the same time, we have to set some limits. And these limits can be the reinforcement of the role of the institutions, the European Commission, but also judicial authorities. There can be also the need to set some red lines, and for sure, rule of law is one of those. So thank you very much for your words, and thanks for taking the time to join us today. This is the concluding part of our conference, so let me just take 1 minute to thank warmly of the people that collaborated to the realization of the event. First of all, the EPC team, our partner in this, starting from Johannes Groibel, Corina Statulat, Natalie Henry, Clara Redondo, the communication team, Lucasta Bath, and of course the Istituto Affari Internazionali team that accompanied me in this long journey, not only today. Matteo Bonomi, who was our assistant project coordinator for the EU IDEA project, and Elisabetta Farroni, the pillar of our organization for this event today. So thank you very much, and we can enjoy lunch. Thank you.